we decide what we want to do in this town, right? Mm-hmm. So, for example, today we've decided this hour between 8 and 9, we are going back to Thursday. It's our Justice Thursday conversation, and we are joined by Lady Justice Josephine Mongare of the High Court. Good morning, Judge.
Good morning.
How are you?
I'm great, and you?
Very well. Mm-hmm. Welcome to the hot seat of the Kenya's biggest conversation.
Thank you.
Judge, you're in the dock.
Thank you.
This is a 3-judge bench.
4-judge bench if you include me.
No, you're not. Your Ladyship, you're in the dock.
Oh, I am the
Here we have stripped you of any of that such titles.
My office is constitutionally held. I don't think you have the power to do so. You need a tribunal to strip me.
We, the sovereign, can exercise our power.
You, the people.
Directly.
Or
the people may. Not shall. The people shall.
The people will.
Karibu sana.
Yes.
Kenya's biggest
I'm happy to be here. Eric and team, thank you for having me this Thursday, Friday.
Yes.
As the High Court, I have been detailed by my principal judge to come and speak about what we're going to have next week, the inaugural annual High Court Summit, where we'll be discussing upholding human rights in a changing Kenya. The High Court is the only court in the country that is bastion of the Bill of Rights, that we are empowered by the Constitution to interpret and ensure that human rights given to the Kenyans and the duty bearers of human rights as a government and the other actors are held to account if and when they run afoul of what the tenets of the Bill of Rights in this country and in our 2010 Constitution entails.
Very good.
Yes.
Very good. We're going to have an interesting conversation. City, please give the judge the day's proverb.
Yes.
Just listen to the proverb and give us your interpretation of that proverb.
Our proverbs the whole of this week have been from the People's Republic of Mozambique. There are no shortcuts to the top of a palm tree.
There are no shortcuts to the top of a palm tree. It's very correct. There is no shortcut to the top of the summit. You must walk the steps. You must take the journey. You must do the hard work.
Okay.
Yes. That's my understanding of that. It's a correct proverb.
You cannot bend a palm tree to tap wine.
You can.
You must climb it.
You have to climb it.
Yes.
So the International Human Rights Day is commemorated every year on the 10th of December. Is that the day that the judiciary wants to have the annual High Court Summit?
We will be having the summit for 2 days. That is on the 10th and the 11th. This actually was arranged to coincide with the International Human Rights Day, and we said, as the custodians of the Bill of Rights, what better way to to commemorate this and celebrate with the rest of the world the International Human Rights Day. So our conference will be for 2 days. We will be here in Nairobi at Safari Park, and we brought in all our 96 judges from around the country and the civil society's actors who have also partnered with us in this journey. But let me just tell you what we did prior to next week, which is the big day. When we conceptualized this, we said, because the rest of the civil society actors are commemorating the 16 days of activism that begins from the 25th to the 10th of December, what can we as a High Court do? So what we did, we started a lecture series. We have been to, I think, 10 universities. We talked to law schools. We started with Kabarak, went to Kisii, who are the University of Nairobi. We went to Chuka, we went to Kisumu campus of the UN, and we spoke to Garissa. Garissa University does not have a law school, but it does have a social science humanities section. And we felt that this is not just a legal talk. It's a talk that reverberates and cuts across everyone. And Masinde Muliro, we had 2 weeks of discussions with the university students, trying to open up what does the High Court do, what is it that the High Court is called upon to do, and how do they do it. So we sent our judges to those schools, and the activities were well received. We also had what we call the prison decongestion. We have the criminal division of the High Court does have what we call the CSO desk, which is the community service order, where regularly we go and look at the prisoners and we say, are they right to be, left in prison, or is there something that we can do? Are the appeals taking long? What can we do to decongest and to reduce the numbers? So this last 2 weeks alone, we did over 6,000 matters. We reviewed 6,000 matters because the High Court does not just do criminal appeals. We do what we call criminal reviews and criminal revisions. So at that, as a build-up to this event, we had decongestion in 10 counties, in prisons in 10 counties, and our judges went to the prisons and reviewed all those people who are held in custody, either in remand or in pending appeal, and fast-track those cases that required just look at the length of sentence, decide whether it was appropriate, or whether this is a case where someone can be released on bond or a fine as opposed to custodial service. So we've been able to reach at least 6,000 prisons in 10 counties. Remember, the High Court is spread across 47 counties. We are currently at 47 stations. The only county that doesn't have a High Court or a High Court sub-registry is Garissa. But under the Chief Justice's mandate and the STAJ, we hope to reach all the 47 counties with at least a High Court in every county. Even in Lamu, where we don't have a High Court, we do have a sub-registry for the High Court. We've just had the High Court open a series of High Courts this last term. We had a new High Courts opened here in Makadara. We had High Courts opened in Kibera, Isiolo, Olkalau, and Mandera. Mandera, we now have a sub-registry. So where we don't have a physical High Court, we have what we call the sub-registry. Sub-registry means that you can file your cases at that particular point, but they can be heard by the nearest judge, either as a visiting judge or just now you know that the High Court is fully digital since July.
Yes.
And we do take our cases from wherever we are, where it's possible. Where we have to visit the court, then the judge will travel to the region where there's no High Court.
Judge, if I just come in here, what is the connection between the High Court and the Bill of Rights, Chapter 4 of the Constitution of Kenya?
Under Article 165 that sets out the Bill of Rights, the High Court has what we have, we call the original and unlimited jurisdiction, and it's the custodian of the Bill of Rights, such that all matters touching on the Bill of Rights start at the High Court. We are the beginning. That is where you bring all cases on where you want to enforce socioeconomic rights, your personal rights. So the High Court is the custodian of the Bill of Rights.
Now, that would require that people know
Yes.
the Bill of Rights.
Yes.
So then they can come to the High Court and seek interpretation or seek enforcement of their own rights.
Yes.
Do people understand the Bill of Rights? Let me just read a bit of it. Article 19 of the Constitution, the Bill of Rights is an integral part of Kenya's democratic state and is the framework for social, economic, and cultural policies. Basically, this one is saying that this is the skeleton that forms this human body called the Democratic Republic of Kenya. Do you think we have internalized that?
Most people actually do know.
Citizens or state actors?
Even citizens. If you look at the thriving litigation, because if I tell you now, we have 96 judges and each judge has 700 cases.
Each judge has
each
700.
of the 96 judges of the High Court under at least 700 cases. And in my division, I sit in the in the commercial and tax division. We have over 300 cases being filed every month. It just shows you the trajectory of how much litigation we have.
So litigation equals, and we can say
most
that
people are seeking to enforce their rights.
Okay, so there's so from what you're saying, there's an understanding across board.
Yes.
That if there is a violation at some point, that most Kenyans then are aware that the court is the place that I can go to have this particular issue ironed out.
Yes, and that's why at Nairobi we have a dedicated division, the Constitutional and Human Rights Division, where most of these cases are started. But across board, all judges have what we call the original and unlimited jurisdiction. You do not have to come to the Constitutional and Human Rights Division in Nairobi to have your rights matters determined. Every judge of the High Court has that power and that mandate to interpret the Bill of Rights across Kenya. You go to Lodwar, where we have the High Court, you go to Malindi, you go to Mombasa, you go to Baringo, you go to Kapsabet Court, you will get your Bill of Rights interpreted by the judge in that station. They have the mandate, they have the jurisdictional power.
Okay.
Yes.
Can you invoke these rights after the fact? And I ask this because if, in fact, there is some kind of ignorance at play, let's say, for example, that I come before court, I've been brought, and trying to settle a matter with another individual, and I'm not aware of rights that I may have, that somebody has brought a case against me. The case has already been brought before court. It's been filed. We are going on in the sessions. Can I invoke a right that I may not have been aware of that essentially would help my defense?
Yes.
After the fact,
yes.
and be brought from the knowledge of the judicial officer?
That's why we do prison decongestions. Because you realize people are put to prison for many other reasons. Maybe there was a brawl in a bar and you find the magistrate that tried you found that you are the one culpable and put you in. But maybe he's the one who started it. And the law, it beats both ways. So when the matter comes to the High Court, we are looking at why your rights violated by that incarceration. Remember, the case has already been concluded. And the High Court has that power to say, no. There was a misapplication of this. The person who is in custody is not the right person. And they'll let you go. Yes.
So what happens in that case?
Yeah.
Your rights were violated.
Yes, then you seek what we call damages.
Okay.
Yes.
So from whom?
Okay, for instance,
because in this
if it's a criminal case, if
it's a magistrate who sent me to prison.
In the first place, yeah.
No. But the magistrate was just an arbiter. Remember, there's a person who arrested you, decided that there was evidence.
Yep.
The magistrates can only rule on the law and the evidence that is presented before them. But the person who made the charging decision is the duty bearer. They're supposed to have looked at the evidence, decided there was a case, and brought it to the magistrate to interpret.
Okay.
So, for instance, if the High Court finds that your incarceration was wrong, they will then now review that judgment and say, you are arrested, you are not supposed to have been arrested. Therefore, your rights were violated. You are free to go. So would you come back, you say, the state is the duty bearer. And the state, in this case, we are talking about the police and the charging decision maker, which is the ODPP. They ought to have made the right decision and brought the right person, or not brought me at all. That is the duty bearer. The state is the greatest duty bearer of our rights.
Okay.
Yes.
But who informs about what may have been either, left out previously? If you find that truly there was an abrogation of these rights at some point, who makes that information known? If I still do not know, would it be my lawyer? Would it be the judicial officer to say, hold on a minute, guys, even after the fact, let's say this person has been sentenced and gone.
Yes.
Is it the judicial officer to go over it again and say, actually, hold on, guys, something here is amiss? Or would it be a legal officer, your lawyer, for example, to say, guys, this didn't make sense? Who makes this information known?
Let me take you back to the decongestion process.
Okay.
The decongestion process is one way of looking at those rights. Are these people in prison supposed to be here?
Okay.
That's where the High Court comes in and say, we have the power to review decisions of the lower court. We have the power to revise. So we have a revision power under the Penal Code and under the Bill of Rights. We have the power to look at what took place and how it was done. And that's why we're talking about having reviewed 6,000 cases. Among those cases, some were found rightly to be in prison. Others were found maybe they're serving longer sentences and therefore their right to freedom has been curtailed and therefore they are released when they are not supposed to be serving. So we compare, we weigh the evidence. What did the magistrate see? What did the prosecution present? And then we say they ought to have been sentenced to 3 years as opposed to 10 years, and we reduce that. If you've already served your 3 years, you go home.
Yeah.
So that's the power to whatever. That is not an appeal. That's not an appeal. That's the power of the High Court to come and look at what has the court done to get you as a Kenyan citizen to prison. And then when we find that there was a gap, or that there was a misapplication, or there was excess in the sentencing, we can review that down and allow you to go home.
I see.
Yes. So if in the end that you found that probably we can find that you are wrongly, if you do an appeal and you succeed, and you establish that you are wrongly charged, you are wrongly prosecuted, you are wrongly sentenced, we then give you we discharge your conviction. You can then go back to the arresting agency and say, you arrested me, the court has found me free. This is what I suffered as damages. And that's what I talked about. You then now come back to court and you say, I'm entitled to compensation, I lost this, I had a job, all those things, the factors that come in to weigh and determine how much was your loss.
I think our system, and we'll talk about this, our system in the way it's structured, there are very many ways in which the system propagates the abuse of people's rights. And we can discuss this a bit in detail. We are having our Justice Thursday conversation this Friday morning. Well, because we can, it's our show. Lady Justice Josephine Mongare from the High Court is here talking about the role of the High Court in upholding human rights. Next week, the judiciary will be holding the annual High Court Summit. No, annual High Court Summit on human rights, right? And it will be looking at what is it that the High Court is doing to uphold human rights. Judge, listen to this practical case. Somebody is arrested and accused of defiling his daughter. The case goes before the police. Police take it to the prosecutor. Prosecutor takes it to court. The court listens to the evidence brought before court, and the court is convinced that this person is guilty, convicts him, sentences him, goes to jail. Man appeals. Court of Appeal listens, says that he had been sentenced to 30 years. In fact, stay there for life. And then that 7-year-old daughter is now coming of age and comes and says, I want to revise what I had said earlier. That no. I was actually coerced as a 7-year-old to come and say this. And there is all this that I'm now saying that no, the police were, coercing me and so on and so forth. But basically 17 years later, this person is now being set free by the courts, goes back home. Where are his rights? Where are the rights of the children whose father was taken away from them for 17 years and they've ended up? Is there any form of justice that can come to them? Because you're talking about rights here.
There are several actors in that journey. There
True.
is the complainant who brought the complaint. This child was a minor.
Yep.
There was an adult in the conversation.
There was.
Because minors have no capacity to press on charges, especially at the age of 7.
Yep.
Because the age that you can start looking at a minor with capacity is the age of 12 and above. So there are several actors along the journey. There is the police. They weighed the evidence, and the police acted on the information they were provided.
There's a medical professional who did the
There was a
report.
medical doctor who came and said, hey, look, yes, there was defilement here, and yes, we've taken, because there's a lot of evidence that goes into charging.
Yep.
Remember, there's going to have to be a medical report to show that there was defilement. There's going to be a linkage between the accused and the defilement.
Yes.
Was there any DNA testing that connected whatever was found on the child on the man? And that's the evidence that the court uses. Now, when, as a court, you act, you look at the facts and the law. And that's it. You are not outside there. So the facts are brought to you by the charging authority, that is the DPP. The DPP has collected it from the arresting authority, that's the police. Those are the two state actors in this one.
Yeah.
But where do they get the information? There is an adult who complained, because this child had no capacity to complain. And even if they did, they were no capacity to manufacture and bring this evidence. So when this person is eventually released, there are all those other things. But remember, what has the court done? The court at the trial level looked at
The evidence
what was
brought
said.
before it.
They interviewed people, they had evidence given by the accused persons, and they relied on that to make a finding of guilt. The High Court came and upheld that finding of guilt. They reviewed what the magistrate did, because at appeal you review. The High Court, of course, because the court of first record after the appeal, can relook at the evidence. But the Court of Appeal only looks at the law. It says, did the High Court judge apply or interpret the law correctly in this Sexual Offences Act? Did the sentence commensurate with what is set out after you look at the facts? So where does this person's rights lie? You have to move back to the actors in the whole system. Who misled the police? Were the doctors' reports doctored? or were they correct findings of, that's a science. So the court, you cannot say, okay, now I will sue the court because I was whatever, because the court relied on what was brought before it. And remember, in making a decision as a judge or a magistrate, a judicial officer, you rely on what is availed to you. You listen to Eric Latiff. He testifies, I was there, I saw, I picked these clothes. You listen and the doctor says, we did this, the DNA matched with the dad. And you say, yes, this child was defiled. So what is the court to do?
It relies on that.
Yes.
Now,
if you want to go and look for who then is responsible, look at where the conversation began.
The actors.
Yes.
This is where I wanted to, I was raising that issue.
Yes.
Just as a point of argument, that maybe the way we have structured our judicial system then allows such loopholes to happen. Because this judicial officer, the magistrate, the judge, is only looking at what has been brought before them. So if there's some level of conspiracy or errors of omission by any of these actors, then somebody ends up getting the short end of the stick. And the judge or the magistrate is not going to get out of the court. You can see that there is what is being brought here by the defense. The defense is not questioning very many questions that you can see as a judicial officer. But because the defense is not questioning, you leave it at that. And so that then sets you up to get your rights being violated. That's one side. The other side is at the point of sentencing. Do you then have any say on what then happens? This is the father of a 7-year-old and a 9-year-old.
The greatest duty bearer to protect that child.
Yes. As you send them to prison, are you also asking, so where do these children go? Because then now there's a right of the child. And this is a child who has lived with this for 17 years. By the time this child is coming to the father and saying, I want to tell the truth, this is a child who has lived with this and has been tormented by this for all those years.
17 years later, can a 7-year-old recall what happened? Maybe, maybe not. But what I'm saying is this. At the time of interpreting the law, remember, this is an adversarial system. The defense has their say. The prosecution have their say. Did the father say, this is my evidence, I wasn't at this place, I was here, and the court ignored? You understand?
Yes.
Because that is why it is an adversarial system. Our judicial system is adversarial. Each side gets to say what happened. Then the arbiter, who is the judge or the judicial officer, decides which side is more believable. Now, let me answer you at sentencing. The sentencing guidelines tell us what are the do's and the don'ts when you come to deciding cases. There are those cases with maximum or minimum sentences that you cannot go below. And the Sexual Offences Act is one of those laws. Although, of course, the court is increasingly interpreting and saying you cannot tie the hands of the judicial officer because there's what we call discretion. I observe you and I say, this one has a guilt me, and in my discretion, I think maybe not, So if you look at the recent decisions that have come out from the High Court and the Court of Appeal, they are saying these minimum sentences may not be, so, and they are being revised, and, the court is being very proactive about that. But when you come to sentences, you look at what is the sentence set by the law. What has happened in the interceding period? Was this man in custody for 5 years, for instance, as the case was going on? Then the law, or at least the sentencing guidelines, allows you to apply those guidelines in being giving a reduced sentence or an increased sentence. Now, the rights that have been violated, the question is, who is the person who violated those rights? How do you get to the convener, the person who even put together the evidence, brought it to the investigating officer, brought a police, a medical report, had a doctor convince the court that there was a DNA match, that not only was there defilement, but this was the defiler.
Yes.
You understand? So there's more that goes to decision making than she said, he said. There is what we call the evidence that is brought, the forensic evidence that is brought, that now persuades you that indeed the accused is guilty as charged.
But let me ask this, Justice.
Yes.
Where do we, or if we do at all, we now consider the rights of the judicial officers You mentioned at the beginning of the number of cases that are filed on a daily basis. Is the judicial officer really in the right frame of mind to manage these issues judicially and to actually give the time and energy and focus that each and every of these cases is actually, what is demanded of them? Is it actually humanly possible?
That's why the court has come up with very innovative systems of making sure that most of the cases that are not supposed to be in court are diverted. And now the court, especially the entire court, the entire judiciary has adopted what we call the AJS policy, where we are trying to say, are there any other ways we can resolve these matters away from having the judge sit and hear? Every day in my court, I look at matters and I ask the parties, can you discuss? Is this a matter you think we can refer to mediation? We have what we call the court annexed mediation that takes off a bit of that pressure. Of course, the establishment under the High Court Establishment Act was supposed to have at least 200 judges, so that we reduce these cases to about 300 per judge. But budgets, the recruitment process, is not easy to find a judge. To hire a judge and maintain one at the current budget constraints. So even being at 96, we are at an improved level. When we came in, there were 65 judges. We were hired 2 years ago. In that period, 40 judges have been hired. So the number has gone up. Remember, we also have, age-related retirements, attritions, and judges must exit as they come in. So because of the budget constraints, you realize that the court has had to innovate. And we have what we call Mahakama Popote, where we find if in a station you have less cases, then cases are sent to you from other stations. And because of the digital space, we have been able to achieve that by and large. Of course, the workload is high. The workload is extremely high. And I can tell you for free that in a good day, I look at a cost list of 40 cases. When I look at a cost list of 40 cases, 4 of these cases are hearings with evidence. I can only humanly hear at most 2 cases a day. So what do? I push them to the next day. And then I look at 6 to 10 applications. There are submissions to be made by lawyers before me so that I can make a ruling. And then, of course, the rest are mentions, directions, and managing the rest of the court docket. So the court requires more resources. As a court, the entire judiciary requires more resources from the nation. We are the third arm of government, but we get less than, I don't know the budgeting bits, but what is allocated to the court is not able to bring in enough judges. Even JOs, we are at 600 magistrates to manage the workload and the caseload that is in this country.
Brings me back to that argument.
But what the court has said, have we sat down and started crying, oh, there's too much work? No. Through the STAJ, that is the Social Transformation for Access to Justice, the court has embraced AJS. And we have a full-fledged policy on AJS. We are diverting cases that need not or can be determined elsewhere, to be determined by the Council of Elders, for instance, by the court annexed mediation docket. At our division, we have arbitration as a full-fledged way of removing commercial cases that can go to the arbitrators under the Chartered Institute and elsewhere, so that we reduce the workload and we make sure that the wheels of justice move faster. We now have a policy that a 3-year-old case in the High Court is an old case. And after 3 years, we consider that case to be backlog.
What do you mean by 3-year-old?
Any case that was filed 3 years ago should be determined within that framework, so that we can say we are up to date. But can we actively manage that? It's beyond.
It's humanly not possible.
Yes. So what we do is that now, because we don't want to have these cases there, you have these parties talk to our court annexed mediators. They look at the issues, they frame these issues, and they say, yes, I think I can bend and agree to a lesser settlement, or we can reach a win-win situation. And of course, mediation allows parties to still remain friends, because it's not a winner-take-all. But the judicial system, the justice system is set up on a winner-take-all. So when we offload some of the cases to the AJS platforms, of course, then we are able to manage the workload.
I asked the question, if the rights of the judicial officers is violated, what then you do? You open a door to having a situation where those who come to your courts cannot fully hope that their rights will be looked into. I'm going to give you an example of what I mean. I worked in the field of HIV and AIDS, and one of the things we did as a preventative measure was voluntary male circumcision. And there were things we referred to as incidents as adverse events, where in the process of circumcision, something else is nicked which wasn't supposed to be nicked, or there's an accident. The demands of those who funded these processes required you to perform the procedure. They give you the number. You want to perform this number. All the incidences that were reported would occur when the 17th patient, the 18th patient, and if you look at the process that it took, it means someone was already tired. But in your case, this isn't fatigue, it's exhausted, because this is something you do every single day. Now, this is just the physical toll. There's the mental and the emotional toll that comes with just the work that you do, what you handle. Because one cannot run away from, you're reading it, you're listening to these things, it will affect you. So let me ask the question. In addition to this is an addendum to what I had asked. How do officers of the court debrief? How do you get to be able to resolve and find solace with all the pressure that comes with what you do?
The court is structured in such a way that we have 3 terms in a year. And in between the 3 terms, we have what we call vacation. Like now, we're just about to go to the Christmas vacation where we'll have a 3 weeks break to go home. Probably find time to look at your files now and write your pending judgments.
But then you're not resting.
I'm just explaining. But at least you are now not listening to cases and writing judgments at the same time. You understand? So the vacation allows you a bit of a break to go and look at yourself, to go and look at what is pending before you, and to see how you can manage it. But we now, within the judiciary setup, we have a psychosocial unit, and we also do have an annual yearly wellness program for the judges, where we come and bring them to doctors, medical people, these physical exercise experts, and they talk to judges on how to do self-care. Of course, self-care is personal. But with the workload, it becomes a balancing act. So do you ignore the pressures of work, or the cries of the people in prison who want you to go and decongest, who want you to hear their appeals and say, now it's time for my self-care? And of course, judges take their annual leave. So there is a way you can, with a balanced workload, you can, yes, in a small way, look after yourself. This conversation at the annual summit is outward looking. Let me explain. And we have brought in some of our stakeholders to start having these conversations. How do we support also the wellness of the judge? You understand? So we are going to have not just the lawyers, not just the judges. It's not an in-house, talk shop. We are going to have civil society actors, people who come to our court. It's what we are calling a big CUC. A big CUC, what we have, the court users committee, people coming in, and we are telling them, this is where we are starting from. This is what we go through. How do you, as actors of this court, come in and help us achieve a balanced judge who is able to do their work and not burn out and doesn't retire to just go and die tomorrow? Yeah. Because they are exhausted, they are bent, they are spent. By the end of writing a judgment, I actually feel emotionally exhausted.
Drained.
Because you must read and remember what those people said in court. And so the summit is one way of having this conversation. Now taken out, usually the High Court will have their own High Court leaders, the colloquium, those events, and the wellness, as I talked about, where we go and debrief. But now we have said, let's bring in our court users. Let's bring in our stakeholders. Let us have a conversation. Judges also have human rights too. You understand? So how do we make sure that we are also not violating their rights when they uphold other Kenyans' rights?
Do you think it has had any kind of impact? I mean, I just hear you now, and I remember that we had conversations even with technology of courts and users and things like that. Do you think it has an impact, or has it had an impact in the past? Just when you talk about being emotionally drained after doing a judgment, I think of the, judicial officers in different courts, whether it's criminal court, whether it's civil, and does it have any impact on the judgments or decisions that are made? I mean, it would, because you're dealing with human beings. These are not Martians who don't have feeling. Does it have impact on the decisions made?
Remember, decisions are your personal interpretation of what happened after you look at the law. You look at the law, that's why you're trained as a lawyer. And so you come and look at the facts as they were presented to you, look at what the law guides you to do, and you do it. So, of course, it's an emotional decision. It's a personal decision. I was there. I looked at the evidence. This is what the evidence says. And this is what the law allows you to do. So, of course, going digital, one, has actually increased our workload. Because now you work 24 hours. I wake up at midnight. I find certificates have been filed. I give orders at midnight. There's no time. I cannot now say, oh, I'm traveling from Ombaso. I cannot take the course. I will go to the nearest hotel, find Wi-Fi, sit down, take my course list, and then travel. So it even gives you less wiggle room.
Yeah.
And now people are saying, I filed my case. In fact, if I haven't taken yesterday's certificates, by the time I get to the court at 10 o'clock today, I'll find 3 letters to the DR saying, we filed the certificates yesterday, the judge has not looked at it, our property is being sold, and therefore there is an increasing demand. Before we used to say, oh, Saturday, Sunday, you cannot see the court doesn't sit. Yeah. The court now sits 24 hours.
Because we can access it 24 hours.
The court going digital means that the judge has more work and more opportunity to look and decide those cases on the go. But yes, it doesn't, that's why now the court and the entire judiciary has come up to look at how then we support the judge. The judges have their annual leave. The judges have a good medical cover. If you are under the weather, you can go, like I've been unwell, you can go and see a doctor of your choice. And we have the psychosocial support unit in judiciary that you can go and talk to someone and say, hey, apa, imenichapa. I'm having bad thoughts.
And I think the bottom line, Judge, is just all of us to agree that for us to actually get our rights defended and to be able to defend our right properly, then we need the arbiter to be working efficiently. So put in more money to hire more judges.
Correct.
Put in more money to support the judiciary so that then we can get those rights.
And build more courts.
Everything to make sure that our justice system is working. Lady Justice Josephine Mongare, Judge of the High Court, has been our guest telling us about the role of the High Court in upholding human rights. So next week, the 10th and the 11th, you have the summit, which will be looking at addressing what the High Court has been doing. It will be, of course, along the International Day of Human Rights.
This is the Situation Room, the only way to start